Welcome to the debate, the final stage of the journey toward citizenship, the naturalization interview based on the N-400 application is often the culmination of years of preparation, and it concludes with a very binary decision, approval or denial.
And that denial, which can stem from something as straightforward as failing the civics test to, far more complex foundational concerns like meeting the requirements for good moral character, presents the applicant with an immediate high-stakes dilemma.
Exactly. Our core question today centers on the immediate aftermath of that denial notice. What is the strategically sound response? Should the applicant utilize their statutory right to administrative appeal, challenging the decision via the N336 process to rectify potential administrative errors?
Or should the applicant prioritize the mitigation of enforcement risk, bypassing the appeal entirely to avoid the profound potential for greater scrutiny, which, given recent policy changes, could expose them to immediate deportation proceedings?
I hold that the administrative appeal process, the mechanism provided by the agency itself, is a crucial administrative check designed to rectify agency errors. It should generally be the default action for denied applicants, especially when the grounds for denial appear technical or factual. The system is designed to correct itself.
I come at it from a different way. I would frame the decision not as, exercising a right against bureaucracy, but primarily as a critical risk assessment problem with existential stakes. The objective must be survival within the system. That is, avoiding removal proceedings, making strategic waiting and refiling the safer default path for most vulnerable applicants.
Well, let's focus first on the structural integrity of the process. The system grants the applicant a statutory right to a hearing, known as a de novo review. This means the case is taken up entirely fresh, reviewed by a different immigration officer who must be of an equal or higher grade than the original adjudicator. This structure is specifically intended to root out misinterpretations of the law or simple factual mistakes. We know this process is viable because the numbers bear it out. Historical data shows that administrative appeals are frequently successful. Well over half of the appeals filed annually generally result in an approval. If the error rate is that high, the appeal is, it's essential.
I see why you rely on that success rate, but let me give you a different perspective built on systemic risk, the risk of the Notice to Appear, or NTA. Since the agency implemented its policy to issue an NTA, which immediately places the individual into removal or deportation proceedings, when certain naturalization applications are denied, seeking an appeal actively risks exacerbating the situation.
I see.
An appeal compels a second, higher-level officer to conduct a completely fresh look, a de novo review, which may shed more light on the case than the applicant ever intended. So if the applicant has latent, underlying grounds for deportability, that appeal significantly increases the risk of an NTA being issued and the end of their legal status.
But surely, if the denial is based on a clear, curable administrative error, like an officer miscalculating the period of physical presence, or if the applicant failed the English or civics test once, where they are explicitly entitled to a second chance, forfeiting the appeal in those scenarios means abandoning a statutory right and immediately accepting the significant cost and, the prolonged delay of having to refile a full application later.
That's a compelling argument for the person with the pristine record. But have you fully considered the actual extensive scope of review during that appeal? The officer is explicitly permitted to examine conduct that occurred prior to the statutory 5-year good moral character period.
Right.
This isn't just about reviewing the last 5 years. This means the applicant's entire legal and criminal history since they entered the country is subject to scrutiny. If the applicant has potentially deportable conduct, for example, involvement in human rights violations or certain types of aggravated felony convictions that occurred even decades ago, the appeal serves only to confirm latent issues that might have otherwise remained dormant.
That brings us squarely to the tension between mitigating immediate enforcement risk versus fighting administrative error. So let's start with a crucial hypothetical. If the applicant is denied for a purely technical reason, say they lacked adequate documentation for a tax liability, and the denial notice does not include an NTA, why gamble on inviting the worst? Why assume an enforcement action that hasn't materialized yet? If the denial is based purely on a technical error, refusing the N336 means forfeiting a chance at immediate approval and paying the full application fee again later. The documented success rate of the appeal process strongly suggests these errors are frequent and are successfully overturned, confirming the appeal is indeed a crucial remedy for agency mistakes.
Of course, if an applicant has any of these latent issues in their history, an appeal forces a new officer to review their entire record against these permanent standards. This is an immediate, irreversible high cost when a safer path, waiting, correcting the underlying deficiency if possible, and refiling exists.
I agree that where permanent bars are at issue, the calculus shifts entirely. In those cases, appeal is certainly ill-advised. But let's look at the procedural mechanism that the appeal offers for the majority of applicants who do not have such existential risks. When you file a naturalization application, the agency is mandated to issue a decision within 120 days of the initial interview. If they don't, the applicant gains the right to seek judicial review in district court.
Right.
So, filing the administrative appeal keeps the case firmly within the statutory process and requires the agency to schedule a review hearing within a reasonable time, generally not to exceed 180 days from the appeal filing. This forced timeline is vital. It maintains the applicant's momentum towards citizenship and compels bureaucratic action. If they choose to wait and refile, they lose this momentum entirely.
I'm not convinced that procedural speed outweighs safety, especially when the underlying reason for denial is a statutory deficiency that cannot be fixed by an appeal. Let's take the classic scenario, a client who was denied because they failed the continuous residence requirement, perhaps due to an absence from the U.S. that broke the continuity, or they lacked sufficient physical presence. They are missing time. The appeal cannot fix a broken clock. They cannot gain that missing time administratively.
Sure.
For this person, filing an appeal is simply wasting the appeal fee and precious attorney time on a review that is guaranteed to fail, while simultaneously exposing their record to the enhanced scrutiny of a higher-level officer. The rational legal strategy is to wait until they have accrued the necessary time and then submit a brand new application, completely bypassing the enforcement risk.
A further consideration, which I think is crucial to equity and access, is the restriction placed on economically vulnerable applicants. Those who need financial accommodation, such as a fee waiver based on income guidelines, are restricted to filing a paper application. They cannot file online.
That is correct. Those who need financial help are limited to the paper filing channel, which we know is consistently slower.
And if they suffer a denial, forcing them to wait, accrue time, and pay to refile exacerbates the procedural and financial barrier already imposed on them. They are sent back to the queue for another multi-month or year-long wait. The appeal, though it has its own separate fee, offers a path to immediate, mandated resolution for these applicants without forcing them back into that agonizing queue.
That is a very important point regarding the procedural barriers for vulnerable applicants. But we must maintain the intellectual distinction between an administrative failure and a fundamental statutory deficiency. Let's focus on the incurable issues. If the denial is based on a foundational eligibility requirement, such as the USCIS officer determining that the applicant did not properly obtain their lawful permanent residence status in the first place, a possibility they review aggressively at the naturalization stage, no amount of re-examination under the appeal process will cure that.
No, it wouldn't.
The appeal simply confirms the lack of eligibility and dramatically increases the NTA risk, as the agency has now been twice alerted to the fact that the applicant lacks a valid path forward.
Conversely, if the denial was based on a common, curable error, the appeal acts as the necessary safety valve. Imagine an applicant who provided clear evidence to rebut the presumption of broken continuous residences after a 6-month absence, but the officers simply refused to accept that evidence or miscalculated the dates. Or consider an applicant who failed the civics test not because they didn't know the material, but because of severe test anxiety. They are entitled to a second attempt. The appeal is the specific remedy for these human or computational errors. It guarantees that a high-stakes, multi-year process isn't finalized by a single rectifiable error.
In essence, the choice between appeal and refile forces the applicant to bet on the nature of their record. Is the denial due to an administrative fluke, or is it a symptom of a deeper, pre-existing vulnerability?
Indeed. The decision is a sharp legal tool, but one that must be handled with extreme care.
Ultimately, the administrative appeal process serves as a critical check against administrative error. It provides a statutory mechanism for a second, fresh look at the evidence and compels action from the agency within a set time frame. For applicants who have undergone meticulous risk screening and have sound immigration histories, it is a powerful tool that should not be discarded simply out of fear of generalized policy risk.
Yet, the inherent value of the appeal must be carefully weighed against the irreversible risk of triggering removal proceedings, particularly when the applicant's historical conduct, including pre-statutory period good moral character issues, is vulnerable to deeper scrutiny. For many, especially those with deficiencies that require the simple accrual of time, the most pragmatic and least exposed path is curing the deficiency and refiling the application later.
The source material clearly outlines that the decision to challenge or wait is not a simple choice, but a complex strategic calculation, where the procedural benefits of the appeal must be meticulously balanced against the potential enforcement consequences revealed by further administrative review.
There is certainly more to explore in the statutory framework governing these post-denial procedures, and the specific facts of the applicant's record must, in the end, determine the strategy.